Hello, my name is Toru Kobayashi. Today, I'd like to talk about the basics of private trusts. First, I'd like to talk about how trusts work and their key features. Then, I'd like to look at various methods used by private trusts and discuss the coordination between trusts and adult guardianship. First, I'll explain how trusts work and what their key features are. A trust is the legal arrangement in which a person, called the settlor, who owns property, has another party, called the trustee, administer, manage, and issue payments, called distributing, invest the settlor's property on the behalf of a person or a corporation to whom the settlor wishes to issue payments, called the beneficiary. Some trusts are self-benefit trusts, in which the settlor and the beneficiary are identical. For example, some people might entrust the trustee with the operation of their own property. One of the key features is that when the trust is created, ownership of the trust property is nominally transferred to the trustee. The beneficiary receives what are called beneficiary interest, which are the rights of the beneficiary, but in addition to this, they also receive functions for supervising the trustee. The trustee has the discretionary power to administer, manage, and issue payments of trust property. However, they must act in accordance with the purpose of the trust. The trust does not have corporate status, so corporate rules do not apply. This makes it possible to flexibly design and utilize trusts without unnecessary costs. The trustee's own property is managed separately from the trust property in what is called a trust bankruptcy remoteness function. This protects the trust property even if the trustee goes bankrupt. However, it is important to note that trusts do not serve as tax shields, and trust property is subject to bequest division rules. Next, let's look at the types of trusts and how they're created. First, trusts are categorized as either private trusts or commercial trusts. Commercial trusts are used, for example, to provide greater asset liquidity and to create funds. Private trusts, on the other hand, are used for apartment management, rebuilding, as will substitute trusts, and the like. There are three ways to create trusts, but contracts make up an overwhelmingly large share of them. The second most common way to create a trust is by will. Creating a trust through a manifestation of intention is extremely rare. Trusts can also be divided into self-benefit trusts and third-party benefit trusts. In Japan, self-benefit trusts are common. In this kind of trust, the settlor and the beneficiary are the same party. In the case of third-party benefit trusts, the settlor, the trustee, and the beneficiary are all different parties. There are two types of testamentary trusts. In academic contexts, testamentary trust refers to trusts that are created by wills, but trust banks and other institutions also call their will execution operations testamentary trusts. As part of these will execution operations, trusts may be created by wills. It is important to note that when setting up a third-party benefit trust, the beneficiary is responsible for paying gift taxes when the trust is created. That means that other than exceptions under the Inheritance Tax Act, it is almost impossible to create these kinds of trusts in Japan. Next, let's look at the key features of trusts. The first key point is that the administration, management, and dispersal of payments for trust property are handled by a trustee that you can trust. This ensures the ability to reliably carry out apartment management, asset management, and payment. However, it's vital that you select a trustee that you can trust. The second key point is that the trustee appears to be the owner when performing management, operation, and payment. This improves the effectiveness of these activities compared to using a delegation approach, and also makes it possible to procure funds. From the perspective of the settler, by setting up a trust for their own property, they have separated their property from the trust property, so it's no longer within the scope of adult guardianship while they're still alive. What's more, trusts also have a function that locks in the purpose of the trust, so payments will continue to be made without change even if the settler suffers from worsening dementia or passes away. Another important aspect of trusts is that even if the settler passes away, the trust property is not included in the inheritance. The third key point is that a will can only designate the next successor, and it is difficult to designate a successor to that successor. With will substitute trusts or successive beneficiary trusts, however, it is possible to designate subsequent successors. Please note that only banks, companies, and the like that are licensed and registered by the Prime Minister are permitted to be commercial trustees. Next, let's look at the differences in how trusts and wills function. First, we'll look at the transfer of property by a will. Joint inheritance registration is registering the transfer of ownership of statutory inheritance, and as an act of preservation defined in Article 252 of the Civil Code, each heir can request registration on their own. If an heir is dissatisfied with the will and does not inherit real estate, that heir could perform joint inheritance registration of the real estate anyway. They could then sell their co-ownership interest. This would interfere with the execution of the will, and the buyer, unaware of this, could register the transfer of ownership of the real estate before the rightful inheritor has the chance to do so. Alternatively, inheritance obligees or heirs creditors could seize the property. In situations such as these, the property would be in the name of the descendant, so the heirs that should have received the property according to the will are unable to obtain ownership of the property. Transferring the ownership of property by will is not a completely reliable method under Japanese civil law due to Articles 899-2 and 1013 of the Civil Code. In the case of a trust, on the other hand, the trust property is registered in the name of the trustee, so they can be delivered to holders of vested rights and to residual property beneficiaries reliably without interference, without using inheritance procedures. This makes trusts significantly different than wills. The features of private trusts can be applied in various ways. For example, private trusts can be useful in transferring ownership in cases like these. You're getting on in years, and you want to leave the management of your apartment building up to your son, while you use trust benefits to make up for expenses not covered by your pension benefits. You want to leave fund procurement or the sale or rebuilding of your apartment up to your son. You want to continue to make payments for living expenses for your disabled children or your spouse who has dementia even after your death. You want to arrange for someone to continue to take care of your pets after you die. You can also designate the successor to your successor so that you can transfer specific property without being impeded by heirs. For example, you could pass on your property to your wife and then on to a nephew or niece. You could also designate the successor to pass your treasury shares to. Next, I'll explain the different methods used to create private trusts. First, let's compare trusts with special provisions and will substitute trusts. Both types of trusts can be created by the settler through the use of a trust contract. As I mentioned earlier, with respect to third-party benefit trusts, the beneficiary faces the issue of paying gift taxes when the trust is created. So trusts created when people are alive are almost entirely self-benefit trusts, where the settler and the beneficiary are the same person. When the trust is created, ownership of the trust property is nominally transferred to the trustee, and the trustee manages the trust property. What I've been describing so far is a typical self-benefit trust. In the case of a trust with special provisions are added to the trust when the settlor dies, the trust ends, and the residual property passes on to the holders of vested rights, etc. A 2016 Supreme Court decision clearly states that saving deposits are subject to the division of estates. This has made it difficult for co-heirs to pay for funeral expenses, etc., out of the savings of the deceased before the estate partitioning discussions begin. Money trusts with special provisions have therefore become widely used to take care of expenses incurred immediately after the inheritance proceedings begin. Later revisions to the Civil Code have made it possible for some co-heirs to receive advances of portions of savings before estate partition discussions begin. On the other hand, in the case of will substitute trusts, when the settlor dies, payments to a second beneficiary begin. What's more, will substitute trusts are always created through contracts, so there's no setting up of a trust by the will. With will substitute trusts, when the settlor dies, the trust remains in effect and payments to a second beneficiary begins. Because of the system in which gift taxes must be paid when a trust is created, normally the trust is created with the settlor as the first beneficiary. When the settlor is alive, in addition to the trust property being managed, payments are made to the first beneficiary, who is also the settlor. When the first beneficiary, who is also the settlor, dies, then payments to the second beneficiary begins. This is one of the main features of will substitute trusts. Then, when the second beneficiary dies, the trust ends, and the residual property is paid to the holders of vested rights, etc. For example, a will substitute trust might be used by someone who has no children, so that when their spouse dies, they can return the estate which has been passed down through the generations to another family member. In this case, they would use a private trust in which the first beneficiary would be the settlor and the second beneficiary would be their spouse. The settlor also has the right to change the beneficiary, so they could change the second beneficiary if conditions change. Next, let's look at successive beneficiary trusts. These are also known as sequential beneficiary trusts. With these trusts, when the settlor dies, the trust begins making payments to the second beneficiary, who acquires beneficiary interest. When the second beneficiary dies, beneficiary rights are then passed on to the third beneficiary, then to the fourth beneficiary, and so on. Unlike will substitute trusts, successive beneficiary trusts can be created while the settlor is alive through a contractual trust or by the settlor's will. As a general rule, beneficiary interest expires when the beneficiary dies, so this is not deemed to be inheritance under the Civil Code. However, it is important to note that under the Inheritance Tax Act, inheritance taxes must be paid. Once 30 years have passed since the trust was created, beneficiary interest can only be acquired by the currently existing subsequent beneficiary. Even if subsequent beneficiaries have been designated, they cannot acquire beneficiary interest. However, in cases such as those where the beneficiary are infants, the trust could last for 100 years or longer. Successive beneficiary trusts are also subject to bequest division rules, so when the first beneficiary dies, statutory reserve shares are calculated, including those for subsequent beneficiaries. This figure shows a trust created by a will. When the settlor dies, the first beneficiary acquires the first beneficiary interest. Then, when the first beneficiary dies, the second beneficiary acquires the second beneficiary interest. Each beneficiary receives beneficiary interest when the beneficiary before them passes away, and they keep these beneficiary rights until their own death. When statutory reserve shares are calculated, beneficiary interest is calculated based on the mechanism described here. From here on, I'd like to talk about the coordination between trusts and the adult guardianship system. This table shows the strengths and weaknesses of private trusts and the adult guardianship system. The bolded items are strengths. For example, under the adult guardianship system, when a ward dies, guardianship ends automatically. But with trusts, the period can be defined through contracts, wills, and other acts of trusts. Trusts offer greater flexibility with respect to the selection or resignation of the trustee or guardian, the methods used to manage property, the transfer of the trustee's home, and the like, but their activity scopes are limited to property management. An elderly person might require the assistance of an adult guardian for various things, such as entering a facility, being hospitalized, or the like. Also, the adult guardianship system covers the management of all property, while trusts only cover trust property. So additional thought must be given to what to do about the other property. There's also a lot of debate about which is better, trusts or adult guardianship, but it's actually important to coordinate between both. This is an example of coordination between the two. This particular example is for a situation involving the death of a parent, in which arrangements are made to ensure that the person's son, who has a disability, can live comfortably after the person's death. In this example, the son does not have sufficient decision-making competency, so the father and daughter are both statutory guardians. To ensure that the father can manage his assets and issue payments to his son, he also enters a voluntary guardianship agreement with his daughter. While he is still alive, the father pays for his son's medical expenses. However, he has also separately created a private trust to handle things after his death. When the father dies, a trust bank, etc., or his daughter acts as a trustee and will pay the son's medical expenses from the trust property. The father could also use a specified gifts trust so that the trust bank, etc., would make payments to his son the entire time, including before the father passed away. When the father dies, his daughter will become the statutory guardian. As you've seen, trusts are able to do some things that can't be accomplished with the civil law systems. However, trusts can't do everything, and it's extremely important to select the right trustee. Some of the key features of trusts are that the ownership of the trust property transfers to the trustee, and that you can designate successors and successors to successors. These features are being used by trusts in a variety of real-world situations. Further, the trust and adult guardianship systems can work cooperatively, supplementing each other to produce even greater results. I hope that you keep your eyes on future changes to private trusts and how they could benefit you in the future. Thank you for your time.